Hi, I'm Emily, and I am here with Maya Murphy's attorney, Ephraim J. Fink. Attorney Fink practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fink is, my health insurance company sent me a letter that they want $7,000 reimbursement from any recovery I get from a car accident case. Can they do that?
Good afternoon. Thank you, Emily. Good question. Personal injury plaintiffs come from all backgrounds of life. One could be a 35-year-old man in the prime of his work life, and another could be an elderly retired woman who is receiving government benefits. So depending on their station in life, how the accident came about, and their injuries, claimants may have to deal with issues of reimbursement from a number of sources that were involved in their case and their medical treatment. Examples might include someone may have been hurt on the job and collected workers' compensation. In the event an injured party has a claim against a third party who is not the employer, of course. Medicare, in the event an injured senior citizen may have had their lawsuit treatment covered, or the injured plaintiff did not have adequate health insurance coverage and he owes doctors substantial past due bills that he could not afford out of pocket. So as a result, there may be medical providers, insurers, and governmental agencies that have a claim or a legal right against the potential recovery an injured person obtains via a verdict or settlement, similar in a way to how assets may be used to satisfy a debt. The theory is that these third parties would not have had to pay for medical treatment or lost wages if there's a workers' compensation claim, if it were not for the potentially at-fault defendant who was being sued, who injured the claimant. This is also called a right of subrogation. While not every debt is subject to subrogation, some health insurers, like self-funded benefit plans under ERISA, for example, Medicare, and workers' compensation, must be reimbursed in the event of a settlement recovery or a favorable judgment. Essentially, these parties are akin to creditors, and their liens serve to guarantee an underlying obligation, such as the repayment of medical bills. A personal injury claimant and their attorney need to keep their eye on resolving liens, if there are any, and if possible, within the context of the case. Additionally, sometimes the liens on the case can be helpful for the purposes of evaluating what the case is worth. And the liens can sometimes be negotiated downwards for less than the full reimbursement figure. Collateral source payments from health or sickness insurance, automobile accident insurance with health benefits, or other contracts that pay or reimburse the plaintiff for healthcare services can all be eligible for this type of lien situation. Because juries are not allowed to hear that the injured person had medical bills covered by health insurance, sometimes the lien is also considered a collateral source for which the plaintiff should not get the benefit of getting medical bills paid twice. Connecticut law subtracts the amount of collateral source benefits from the entire amount of economic damages that are awarded to a plaintiff at trial. Money that a plaintiff receives in the form of a settlement is not a collateral source. The damages reductions do not occur for any collateral source which might have a right of subrogation, where that exists, or the percentage of the plaintiff's own negligence. It only comes from monies that were reimbursed by the previous entities we discussed, a health insurer or governmental agency. In New York, the collateral source rule is very similar. It applies to actions for personal injury, property damage, or wrongful death, where the plaintiff is seeking to recover the costs of medical care, dental care, custodial care, rehabilitation services, loss of earnings, and other economic losses. The court can consider evidence that tends to establish that any past or future cost or expense was or will, with reasonable certainty, be replaced or indemnified in whole or part from any collateral source. Collateral sources do not include life insurance or payments from which there is a statutory right of reimbursement. That's the subrogation I was talking about earlier. The New York law provides specific instructions as to how an award shall be reduced in the event that past or future costs or expenses will, with again, reasonable certainty, be replaced from any such collateral source. The burden is on the defendant to prove that a plaintiff's award should be reduced by payments received from these collateral sources. If you are being asked to reimburse your health insurance for your accident case, or if a lien has been asserted on your personal injury claim and you are not sure what to do about it, please call me at Maya Murphy PC today at 203-221-3100.
Attorney Fink is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Fink at efink@mayalaw.com, and please visit mayalaw.com for more information.